But now the situation has come that everybody should have the awareness. Tomorrow, if you do not have the awareness of what is intellectual property rights, especially patents, you will not even get a job. Whether it's science or social science, you may not even get a job in government or in private. It's very difficult. And I had made a lot of efforts to include IPR in the curriculum of all higher education sectors in Kerala. I think it's partially successful now. Even though I tried it almost 15 years back to Higher Education Council, it did not happen at that time. But of late, I see that most of the science engineering courses have this IPR integrated into it. And also, it is very much seen that as part of quality IQAC programs and people for accreditation, it has been made mandatory that IPR awareness is done. So I'm getting a lot of calls from across the state and also country for giving lectures on IPR. So now the awareness on IPR is increasing. Even though the awareness on IPR is increasing, it's found that what exactly is IPR, its relevance, what is the social significance, that is not taught everywhere. So that is why I'm giving a lecture on the trends in IPR, what has happened in the latest trends in IPR, and also the philosophy of IPR. And before coming to patent, I would like to, copyright is already covered by Ajit Prabhu. You know what's the relevance of copyright. Copyright is something very significant because if you're an author of a particular document, if you're author of a book, then you have the right to get the royalty. So one end, you get the right to enjoy the royalty. At the other end, if there is no such a protection available, the real creators will starve. So that kind of thing, that's a social angle of that. And coming to patent, before entering into a patent side also, you need to know about what is going to be patent search. If you are able to do patent search and find out the right kind of documents from the internet, then you will understand the latest literature of any technologies available only in patent repositories or patent databases. So it's a vital depository available. Next time, students, when you are getting an assignment, better don't go to your library for the books. You can definitely go to the library also, but the primary source should be your patent databases where you can search and find out. And also, Ajit Prabhu has already covered on geographical indication, and also said that principle has mentioned about geographical indication geographical indications also, indication tag also. And I will cover it later in my section regarding the trends in geographical indications. Now let me come to the most complex, most important, and the most dangerous kind of IPR, I should say. It is the patents. And patents, what is a patent first of all? Patent is an exclusive right to prevent third parties from making, using, offering for sale, selling or importing a patented product. Please listen. Patent, the person who is holding the patent right gets so many rights, which include the right to make it, right to use it, right to sell it, offer for sale, everything. But again, his rights are negative rights. That means even though he is not manufacturing it, selling it, offering for sale, etc., he has the right to keep it under the patent under the shelf and prevent all others. So there's a right given to the patentee to prevent all the third parties. So who is the first party comes the question. First party is the person who is inventing, that is the patentee, finally who gets the patent. Need not be inventor. Inventor can assign his right to another person and that person will become the owner of the patent. So the patentee. The patentee has an agreement with the government. So government is second party. All of the third parties will not take a license from the patentee for utilizing the patent application, which is the patent which is in question. And now it's granted by government within its territory. So if India grants a patent, that's valid only in India. If US grants a patent, that's valid only in US. So there is nothing called international patent. However, there is a mechanism for filing one international application that will enter to all the national phases later. So it's called international patent application, but nothing called international patent. And respective countries have the sovereignty. I repeat the word sovereignty to decide whether to grant a patent or not. And again, if you want to get a patent, it has to be as a consideration of full disclosure of your invention through patent office. You have to completely disclose your invention, not through newspapers, not through publications. It has to be through patent office. Disclose to patent office. Patent office will disclose to the public after 18 months. This is how you have to do it. And what is an invention? There's a definition for invention as well. Invention means a new and useful solution involving inventive step. So on serendipity cannot be an invention. You should have addressed the issue in detail in industrial sector and found a solution for that. That solution is what we call as the invention, and that invention is getting a patent. So finally, what we can see that just like when you are publishing, you are getting a credit. When you are patenting, also inventor gets a credit. So patent is an award for the inventor and a reward for the investor. Who is investing money on a patent? Maybe a company, maybe an individual who is assured to get the return back. Why? Because when there is a patent, others are not ready to copy it. Nobody will copy your, because you will go to the court and enforce your patent. That person will be in trouble. So you will try to stay away from misusing the patent. Suppose there is a no patent system, all others will jump into it and utilize it directly. So that is why copying will happen, and because of that, there won't be any worthful patents, or nobody will be ready to invest money on that. So encouragement of investment is happening because who is investing money is given some assurance that they'll get a kind of monopoly in the market. The patent is having a monopoly in the kind of monopoly. I won't say it's a monopoly, a kind of monopoly in the market for a short period of time. For a patent is 20 years. And during that period, you can get the maximum benefit out of the patent. That is why patent is an award for the inventor and a reward for the investor. And we are just making a comment on all kind of intellectual property rights. And when a product comes to the market, there are all kinds of IPR in the same product. You consider the case of a pressure cooker. A pressure cooker may have a valve mechanism. That's a technology. So any technology or technical feature will get a patent. And it will have a brand name. And that is maybe Hawkins, maybe Prestige or Maharaja. That is like a trademark. And similarly, the look of the design of the particular Hawkins or Maharaja, whichever whichever pressure cooker you are referring to, that may be considered a Designs Act. That's already as Prabhu might have told you. That is under designs protection. So you have all design protection, you have patent protection, you have trademark protection, all things are coming, all kinds of IPR there is in the single product. And why you are saying, even all of you, when you're wearing a jeans or when you're wearing a shoe, you're also propagating a particular company's trademark, flaunting a company's trademark. So we are also becoming brand ambassadors when you're wearing a kind of, when you're even wearing a carry bag from a textile shop, also you are becoming brand ambassadors. So this is all the relevance of IPR altogether. Then before going to the next thing which I want to say about, I want to say very clearly that patent simplicity is no bar for patenting. Anybody can take a patent on even a simple thing. The only condition is that the patent, it has to have a novelty, inventive step, and industrial application. There are three conditions for getting a patent: novelty, inventive step, and industrial application. If you satisfy all these three things, you will definitely get a patent. But some people think that patent is a barking dog. And I also mostly agree that sometimes it's a barking dog, but it's the barking dog has very strong teeth and very sharp teeth. So don't always think that a barking dog will not bite. A barking dog also can bite. And if it bites, and it will have serious injury for you. I'll tell you an example. For a power of patent, there was a story long back. That is a story between Polaroid versus Kodak. Polaroid was the inventor of what's called instant camera. Instant camera concept was just coming into the market, and Polaroid was brought it to the market. And then knowing that Kodak, the rival manufacturers, went to the market, then they found that it's a new technology. They developed their own technology by themselves. I repeat, Kodak developed their technology by themselves. However, it was the same invention which was brought by the Polaroid. So when Kodak brought their pieces into the market, then Polaroid went and brought a few copies of the Kodak camera, disassembled, and found that it is the same invention though they have developed the technology by their own. Then Paul Roth went to the court and sued against, he filed a case against Kodak. Then to the Kodak court said, for the next 15 years, only 5 years is over, 20 years is the term of the patent. Next 15 years, Mr. Kodak, you stay out of the market. You have no right to use this invention patented by Paul Roth. And they also said you have to pay $1 billion to $1 billion to Paul Roth for settling of accounts. Whatever money you created out of business, $1 billion is a huge amount. You know. It's a huge amount. So that much amount you have to pay to Paul Roth for misusing this patent. So you understood what I'm trying to say. The patent is not always a barking dog. It seldom bites, and if it is biting, then it is very serious injury for all of you. At the same time, why patent systems are created? There is a very famous philosopher called Michael. He told about benefit to society long back in probably in 1700s or 1800. He said patent systems are not created in the interest of the inventor, but in the interest of the national economy. The rules and regulations of patent systems are not governed by civil or common law, but by political economy. You know the meaning of political economy. A country's economy is also dependent on the kind of political system they have. That is why political economy means whether the country is driven by socialism, whether the country is driven by mixed economy, whether the country is driven by capitalism. Once India was a mixed economy, but we moved into capitalism. So all the policies also changed with that. So then question comes as to whether patent is a monopoly. Patent in principle is not a monopoly. It should not become a monopoly also. It is given exclusive right for somebody for a period of maximum of 20 years. And during 20 years, you have the right to use it exclusively. So it's not given to something which is already in the market. For example, if someone is given a right to sell exclusively the sugar, which is already in the market, that's called monopoly. But if you introduce something first time into the market, it was not there earlier, and if you are given exclusive right on this, so exclusive right only, not the monopoly. And we should ensure that such a thing should not become a monopoly. And then, how does that can be assured? How does it? So that is why patent. Earlier I said patent systems are not created in the interest of the inventor, but in the interest of society. So how it is governed? Suppose let us take the case of mobile phones. Now today's mobile phones are more than a computer. You know the old mobiles 20-25 years back. I mean, all people might be understanding. It was very heavy, very bulky. Then its incoming calls were charged, outgoing calls were charged. Now our incoming outgoing is free if you pay a fixed amount. Then it's more than a computer now. It's a mobile phone. Now all this has happened because there is a patent system available. When there is a patent system available, the rival manufacturers will not copy it, because if they copy it, they'll be taken to the court. Instead, they will go and tell the research and development team to come out with a better mobile and a cheaper mobile. So the second company will come out with a better and cheaper mobile. The first company which brought the initial mobile will lose the market. Then that company will go and tell the R&D team that the second company has brought into the market a wonderful, very good, advanced technology which is cheaper also. You need to work on this and come out with a much better technology. So all these things are happening because research and instruction, research and educational purposes cannot be proven by a patent. Once there is a patent available, after 18 months, I said, it will be put to public. Once you disclose to patent office will put to public after 18 months. Once you are getting in 18 months, everybody can use it for instructional purposes and also research. Everybody can read it, understand, do a research on that. Everybody can understand, use it for teaching purpose. Only thing, you should not replicate the product. If you make the same product which is patented, then if you sell the same product, if you stock it in the market for selling the product, then it will become an infringement. Otherwise, you can use it. That is why when a patent is there, its literature is open to the public, they can do a research and come out with a better device. So in reality, no country, no people are going to get exclusive rights for 20 years practically. Even though it's for 20 years, you will not have monopoly for 20 years because another advanced thing would have come. So that is how in the case of mobile, there are not just one or two mobile manufacturers in the world. There are thousands of mobile manufacturers. Because of competition, on every day we are getting a better equipment. Similarly, if you take any instrument, all these patent systems are like that, where you will get a complete advantage of not getting a monopoly for anybody. And then comes but where is an element of danger in a patent system? That's also we need to look into. The danger in patent system comes because of the technological divide between the developed countries and the developing countries. Say, for example, consider US and India. And you can see in space programs, where do India stand and where was US standing? In 1969, we could send man to moon and return them back to Earth. As on today, the maximum advantage that India has done is we could send a capsule outside and brought the capsule back onto, not on the land, dropped onto the sea. So this re-entry navigation, we are just sophisticating now. So how long will it take for India to send a man to moon, at least a dog to moon, and get it back? So the technology divide, you can see that it's more than 50 years, the US and India. So the technological divide is where the monopoly happening. In other terms, I'll tell you, how many of you have a television manufactured in India? It's okay because it's a foreign manufacturer, maybe having a manufacturing facility in India. How many of you have a technology from India? How many of you have a TV which is having an Indian brand? We also had a Keltron, etc. Now it's not nowhere in the picture. This is what happening. Developed countries will be in a position to manufacture their products in bulk in their countries and then transport to underdeveloped and developing countries and dump them there on a cheaper rate, so that the industries in those countries will not grow. Even sometimes, if you are at least manufacturing in this country, they lose the labor from here. That is tolerable. And if they are simply manufacturing in their own countries and then transporting it to working of the patent, we are saying, if the working of the patent can also be met by export. So why can't they manufacture in their country and send it to these underdeveloped countries? That is where patent systems become danger for the countries like India. But we are not advised. We have put into all the patent system laws and regulations, but we have to be very careful. We have to be now think of how to make the inventions happen. We have to compete all these advanced technology worlds, all these developed worlds by advanced technologies and beat it. But our engineers are not tuned for that. Our scientists are not tuned for that. So that is where we lack. And so to your surprise, even today, the major share of the patents are filed by foreigners in India. And we need to overcome this. So why foreigners? And out of all those patents filed by foreigners or Indians, only a very few patents are worked in India. So our remaining patents are simply taken and kept under the sleeve just to ensure that others are not practicing the same invention in this country. So that is something very, very dangerous. And there is one Sir Robert Reed, is a famous philosopher, who told long back, again 18th century or so, he said, I entirely agree about the necessity of revoking patents granted in this country to foreigners who do not work them here. Nothing can be more absurd or mere outrageous than that a foreign patentee can come here and get a patent and use it, not for the purpose of encouraging the industries of this country, but to prevent our people doing what they otherwise would do. To allow our laws to be used to give preference to foreign enterprises is, to my mind, ridiculous. This is said by Robert Reed about England, but it's more relevant for countries like India now. Why are we allowing our laws to be used by others for the benefit of others? But now there's this concept called law of the land. But the law of the land concept is not that much valid nowadays. After the World Trade Organization coming into the picture, people have changed a lot. The countries are going for international obligations only. They are not looking at the interest of the citizens. You definitely have to look at the interest of the citizens. That is very, very important. So the law of the land should be made for the interest of citizens. Why all this is happening? Because an economic invasion is happening. And I don't know whether you understand the word economic invasion. You know, political invasion was there in India by British, and Gandhiji could fight it out. Political invasion, Gandhiji along with others. And we all could do a political invasion fight out because political invasion is visible. but economic innovation is not visible. You need to have much powerful leader than more than Mahatma Gandhi, I should say. Even Mahatma Gandhi may not be sufficient to kick these people who are doing economic invasion and exploitation out of this country. I can tell you a simple example how the economic invasion is happening. On an average, every day I'm getting some 2-3 calls from banks. Sir, do you need loan? I immediately say that I don't need any loan because I don't need really. But it's an easiest thing to fascinate anybody with a loan. It is just like suppose there is a fellow having a big bungalow staying somewhere. He has acres of land, and opposite this bungalow, one small fellow is one person with a small hut is staying. Assume, and with all the effort, he want to get that land used by the person who is having the hut. Under normal course, he may have tried for a political invasion. That is not successful sometimes because there may be many people who will be helping them to prevent that one. But the best thing is that on a certain day, he will go there and he that this fellow is starving for a few days. He would offer him, say, $500 and he would say that you need not return the money. So that person will be happy and he'll also there. So such a great fellow he is and he understood that I'm starving. The next day, that person will come again to your house and he may say, okay, again he will say that, okay, I'm also starving today also. Next day, he may get 1,000 rupees and he may ask for something in return. And third time when he comes and third time this fellow will be tempted to go to the other person in the bungalow and he may ask him for a debt. So at that time, he would ask that you give your property documents to me, Aadharam to me, I will give you more money. So after some time, this poor fellow may not be in a position to pay off the debt. He will have to be kicked out of his place quite legally. I mean, what I'm trying to say with the small story is, this is what happening by economic invasion. When somebody is giving you a loan or something, you are not understanding whether your paying capacity is there or not. So economic invasion always comes in a slow manner. You know what happened to Sri Lanka? And that kind of things can happen to India also if the economic policies are not properly maintained. So these are some of the things I want to say about the philosophy of patents. And now coming to maintenance of project records. If you have an invention, you should ensure that all the property, all the records regarding the inventions are properly maintained. If you are not maintaining your invention records properly, then tomorrow if someone steals your invention, you cannot prove that you are the inventor before the patent office or any court. So maintenance of this one is very, very important by each investigator, and also it has to be signed by the project leader and also by the director of the institute or principal of the institute, or it may be who's responsible. And now patent systems or entire world is now taking a very wild turn. You know, like there were no patents allowed for living things. So surprisingly, in 1841, the Finnish patent on Finland and patent was granted. Finnish patent was granted on Baker's yeast. At the time also, people thought it's on life. It is not really on a life form, even though it's a biological material. It's yeast only. But later on, you might be knowing one name Anand Chakravarti. Anand Chakravarti invented an oil-eating bacteria. That means there were oil spill in Gulf Sea. At that time, he invented an oil-eating bacteria. And difference is that he engineered a bacteria. There were all the time there was bacteria available in the soil, available in the nature. So that such a bacteria cannot eat away the oil. And he went to the US patent office, asked for a patent. Then they rejected the patent, saying that no life forms can be patented. That was the concept all over the world then. Then he went up to US Supreme Court, and US Supreme Court said anything under the sun is patentable provided there is a human intervention. And the court said there's a human intervention on that. He engineered a bacteria. He created a bacteria for the first time. He's a creator. He's an inventor. So why can't a patent be given even if it is on a life form? So that is the first life form which was patented. And later on, Dolly came. The process of making Dolly was given a patent. Harvard mouse came. Harvard mouse is a mouse used for detecting cancer. And that mouse is made cancer and then it is treated. And there are so many biological parts which got patent, and only condition is that there has to be human intervention. There has to be a crucial non-biological step, which is to be inventive, and patent has to reflect the novelty of the invention. And the question is, why discriminate amongst the biological material? And PCR technology was patented. And later on, there is public order and morality is most important. We have created public order. Otherwise, cloning should have happened in human being also, and should have already happened. We don't know whether it's happened in militaries of China, US, etc. Just like internet first invented in military setup. So we don't know if human cloning also might have happened, but that will never get a patent, because once you get it, it becomes stamp of the public. It can only be practiced secretly. So otherwise, you would have seen the patented human clones walking on the earth. So that luckily has not happened. But if there is tomorrow, if there is a third world country, it will be fought using clones only, because clones are no social interaction. So it's easiest to fight using clones. And then they'll use biological weapons. And this is how I'm saying public order and morality is an important factor. That is why if somebody invents a letter bomb, and we cannot give a patent for a letter bomb, because letter bomb, even though it's a fantastic invention, there's no public order. It's against the public order. So anything against public order cannot be given a patent. Similarly, in India, we also have taken a stand that anything contrary to the well-established natural laws cannot be patented. Softwares cannot be patented. Diagnostic methods cannot be. If a diagnostic method is allowed to be patented, then all doctor taking a patent on diagnostic method will not allow to practice the same invention, in the sense, in the same diagnostic method. So that kind of safeguards we have taken. And also India has taken a stand that certain atomic materials, so which is coming under Atomic Energy Act in India, are not allowed to be patented in India. That's one stand we have taken. And another dimension is that traditional knowledge, you may be knowing Parambari Vijnana. Traditional knowledge is also not allowed to be patented in India. Not only in India, elsewhere also, in also all over the world. Why? Because traditional knowledge is only a knowledge. How can a knowledge be patented? A patent is not for existing knowledge. Patent is a new invention which is created, which is not the existing knowledge. So that is why traditional knowledge is something which is passed from generation to generations, and orally, most of the time it's not writtenly available. So that is why it becomes a new. And then it all happened because of some of the issues around the world. You may be knowing the turmeric issue. In 1995, two expatriate Indians, that means two Indians in green visa in US, they know that turmeric was practiced in India for many years in India as a for healing purposes, but the US Patent Office and examiners never knew that it's like that. And these two expatriate Indians filed for a patent. US patent examiner searched in the database. They could not find any documents to stay as prior art. They granted a patent to turmeric. So later on, India, my organization CSIR, fought the case, and finally, and what is her claim for the turmeric was use of turmeric, either intake of turmeric, either you can take inside along with your food, or use the turmeric at the wound site for the healing purposes. When that is done, automatically your healing happens. That is a claim. But this is known to all our forefathers, all our grandmothers for a long time. And then my organization, Council of Scientific Investigation, came into the picture, and CSR argued that turmeric has been used for thousands of years for healing wounds and rashes, and therefore its medical use is not novel of the invention. So if something not novel is given, or something which is practiced in India is given a patent, it is something like it's a wound in our psyche, wound in our own psyche. And then we argued, and finally US Patent Office cancelled this case in 1997. That means its patent was revoked. There was a similar case, also neem. Neem is used when it's put in hot water and extracted, that it becomes a kind of good medicine against fungal, bacterial growth, etc. So that we were used to take bath using this kind of fungal material. You take bath using this neem, but US again, European Patent Office people were not knowing this particular thing, and finally it was given a patent. That was, of course, not again a wound in the psyche. So it was not accepted. Like here also, India objected to it, went on to the US, went on to the EP Patent Office, defended it again. CSIR did it, and CSIR did it, and finally the patent was revoked in 2000. So these are some of the interesting cases which you can even get from internet. And then CSIR started making a database called TKDL, Traditional Knowledge Digital Library. The purpose of Traditional Knowledge Digital Library was to ensure that all this traditional knowledge which are available to public has to be put into a database and handed over to the examiners around the world, patent examiners around the world, so that nobody can misappropriate, take a patent on this particular inventions. Or not inventions, or traditional knowledge. That is the purpose of traditional knowledge digital library. That is thought to be something unique and interesting. But later on, I objected against traditional digital library because traditional digital library was also used for extracting knowledge from knowledge practitioners, which it is not available in the public domain already. I will tell you the difference. In the case of a turmeric, neem, etc., this knowledge was already in the public domain, known to a wide range of people, not just one or two people. For such cases, it is okay to put it in the traditional digital library, but there are cases where that invention is practiced by a small community only, and if you are taking those small communities' livelihood into a database and then giving it to the patent office, it will become dangerous. Because when you are allowing that to be given to a patent office, the examiner cannot keep it secret, because this is a prior art form. It is given as a prior art form in the existing document form. So that means there's a fraud inventor which may come into the picture. Fraud inventor may file a patent application. He may ask for the original document to disprove him. So he may be giving only a minimal details from his side. And not to disprove him, the patent office examiner will have to give the original document for the database. That will become dangerous, that the livelihoods of the common man would be affected. So I opposed it. Later on, we had an IPR policy of Kerala 2000. I was lucky to draft along with Prabha Patnaik, then Kerala Vice Chancellor. So it's
Planning Board Vice Chairman.
Planning Board Vice Chairman, exactly. So Planning Board Vice Chairman. At that time, we had made an IPR policy of Kerala 2008, and we could give a new concept to the world, that why can traditional knowledge be protected in a different manner as a knowledge commons. So we extended further. I later helped Dr. Shashi Tharoor in drafting a traditional knowledge bill we introduced in 2017 in Indian Parliament, and that was lapsed because Parliament dissolved later. In 2022, we again reintroduced it this year, and the concept is we should allow these traditional knowledge holders and practitioners to form their own societies as knowledge societies, and then let them use the knowledge and let them protect the knowledge, and let them decide to whom it is to be licensed, let them decide to who should be the member of the society, like that. And the government should not get involved in all these things. Government should only empower the societies. So instead of government taking everything into the hand, let the societies be empowered, and societies be given the freedom to form the societies, and let the societies protect the knowledge, and any inventions coming out of the knowledge they can think of protecting through patent also. But knowledge as such need not be protected, and they will take care of everything. This is the concept of the bill, and we don't know whether the bill will be taken up or not, because usually when a private bill is filed by an MB, that is not usually taken up for debate. And but if the government takes it over, it is likely to become a bill. But I'm sure that someday this will become a bill. So that we have to wait until that happens. And before finishing off, a few more things I advanced. This is all the recent trends happening in the IPR sector. I'm telling. There are few things which I myself had taken up again. One is a trademark for a deity picture in Nattigal temple. You can search in internet and you'll get more details. I think it was almost 15 years back when I saw a news in newspaper, and it was cited to me by my one of my great gurus, is late Guru Sri Dr. Edi Damodharan. He cited me that, Praveen, you just saw that there's a trademark taken for Ittigal Temple Devi. It is something dangerous for the society. He also wanted to cite it to me, and I took up the case. Then initially I asked all the media to report on this, and none of the media were ready to report. The reason is all the medias were getting advertisement from the trust. And because of commercial interest, no newspaper were ready to report this particular wrong thing. I said, I'm an IPR expert. I want to give me comments. And though I was famous at that time as an IPR expert, none of the newspapers were ready to report it. Then, being angry, I wrote to Kerala High Court, gave a letter petition to Kerala High Court. Kerala High Court took a SOMO2 case. So what? And I'll tell you what's the problem. If a trademark is taken for a tidy picture, tomorrow a modified version can be taken by anybody else, and they can use it even for underwear, manufacturing underwear. You know what will happen to this country, and we know how sensitive is our nation. And in such a condition, we need to safeguard. And very interestingly, the final judgment from the court was that the case was taken by 2 vice judges, and judgment was given by another 2 judges. And they finally said the trademark is okay, let that be used for Annadana. I don't even understand what's the use of trademark for Annadana. You have already heard from Ajit before what is a trademark. So for Annadana purposes, you don't need a trademark at all. So anyway, but the message is very clear. Because I took up the case, they all understood that there is no meaning in taking a trademark like that. If it's not to be used for commercial purposes, what is the purpose of the trust was, if they want to use the trademark to prevent all others, and if any advertisement is taken where they taken the picture of the deity, it was possible for them to get a royalty from. That is the intention of the particular temple trust, and not just any other thing. So finally, they might have managed the things to get an order in their favor, but they stopped advertising that they got a trademark. Actually, when they got the trademark, they had made wonderful advertisements around the city saying that they got recognition from the central government. They stopped all the advertisement, and no other temple in the state or the country dared to do this again. And this was achievement of that particular thing. Similar thing I did was with Tirupati Laddu as a continuation of article. That is also against the faith. Tirupati Laddu was given a trademark geography indication tag by trademark registry, Government of India, and that was for the Tirupati Laddu. Tirupati Laddu, when it's offered to the god, it gets certain qualities. That was the claim of the TTD, the trust which is managing Tirupati Trust. And Tirupati Trust was the richest temple, or is still the richest temple in the world. To fight against richest temple is not easy. Then I want to take it up somehow. And finally, the case dragged on for 4 to 5 years. And the advantage I had, the disadvantage that TTD had, that they had to go for international marketing on Tirupati Laddu. And they failed. They could not do it because of the case. That is achievement. And no other temple. There were temples like even Shabarimala temple and then Ambalapura Palpayasam. They all wanted to go for a GI registration. They all stopped doing it. They understood this dangerous because there are people protesting against this. So there are so many wrong things happening in the society. The geographical indication is made for a purpose. The law is made for 2 purposes, because there should be some recognition for some products which are manufactured by farmers group, etc. They form a society and manufacture. In the case of TTD's Tirupati Laddu, it is not manufactured by a group of farmers or producers. It is by TTD trust. It becomes a monopoly when a GI is granted to them. And similarly, what property is there when it's offered to a god? So this is something questionable. And uniqueness is not. In the case of a Kanchipuram silk, if you say that there's uniqueness in the product gets uniqueness because it's coming from a particular region. So that is very important. So my message is that whenever there is something wrongdoing happens, we should also be able to fight against this. And again, there comes a question like, which one is more important? Is it IPR or a human rights which is more important? I would say, and all of you say, it should be human rights. Put an example. Again, it's almost 10 years back or 15 years back that there were one patented drug in the market by Novartis, company called Novartis, called Glyvac. Glyvac's name is imatinib mesylate, and that is used for treatment of cancer, blood cancer. And when Glyvac brought their patented drug to the market, its cost was almost 2.5 lakh or something for a single dose. And then Indian general manufacturers were able to give the same dose for 30,000 rupees or 40,000 rupees. But they filed a case against, Glyve filed a case against Indian generic manufacturers, stopped all of them. They got an order for injection order from the court. So Indian patients were suffering. So this, then finally, all this Indian generic manufacturers approached the court, and finally, it went on long years. The case went on long years. Finally, it even went to the Supreme Court. And before that, there was a judgment from Madras High Court that made it very clear that public interest cannot be sacrificed. Even though patent systems are granted, it is not for sacrificing the interest of the common man. And also there were some issues like compulsory licensing which happened in India, where one Indian Kerala IAS officer, P.H. Kurian, had taken a very strong decision. All these things are latest trends happening. We have to ensure that human rights are above everything. And now coming to the careers available in intellectual property rights, there are many careers available like IPR managers, the kind of job which I do, the technology transfer experts are needed, patent examiners, trademark examiners, patent and trademark attorneys, patent search experts. There are a lot of potential opportunities available for you. And while that is the case, an exponential growth in terms of patent litigations and patent filing in India in the near future is expected now. While this is the condition prevailing in this country, we still strive for IPR professionals, may it be patent agents, attorneys, IPR managers, or academicians in this field. And in our institute, NIST, we recently started a course for developing IPR professionals, may it be IPR agents, patent agents, technology transfer experts, etc., etc. We have successfully, first batch has come out successfully. We'll be looking forward to the next batch. So for now, attorney outfits are looking forward to grab this potential market of highly skilled labor. So there's a piece of thought for you. Should we act as virtual corporate offices of foreign attorney firms for petty financial benefits, or should we acquire adequate technical skills to counter the invasion of foreigners for whom our national interest is little concerned? So for foreigners, they want to just make money, but what is their national interest for India? They don't have any national interest for India. So we need to understand this particular situation. Otherwise, what will happen when you're working in a foreign company in India for a software, you will get $18 for maybe 1 hour you are doing work, but your company is making $180 from your work. So it's a kind of exploitation happening. So why I'm asking, why can't you set up your own IPR companies here rather than allowing foreigners to take this advantage? So before I end, again, all the things we are speaking about intellectual property rights because of WTO. You know, in World Trade Organization, there were TRIPS. There were so many things happened before 1995. So there were a window in 1995 to 2005. During that window, we had to change many of our laws, and everything had to be put in place. And during this thing, many things changed the world. The entire world has changed. You know, LPG, liberalization, privatization, globalization that has happened. This all happened during that window, 1995 to 2000.